You're listening to The Voice of Russia in London. I'm James Reinl, and we're looking at the deportation case of a radical Muslim cleric. He has been described as a truly dangerous individual and a key UK figure in Al-Qaeda-related terror activity, but sending Abu Qatada packing for Jordan, where he faces bomb plot charges, is not so easy. Together with what looks like government bungling over a date, the case also raises jurisdictional and human rights issues. And it once again pits Whitehall against the European Court of Human Rights in Strasbourg. British lawmakers have wanted to clip the court's wings after a series of judgments that have not gone their way. So, should Abu Qatada be kicked out of the country, and will he? Will the omni-shambles over his deportation end the career of Home Secretary Theresa May? And what are the implications for Britain, the Eurocourt and the treatment of terror suspects? To probe these questions, we're hosting a debate in our London studio. I'm joined by Martin Howe, a human rights lawyer from the firm Howe and Co, Hannah Stuart, researcher from the think tank, the Henry Jackson Society, and Emma Boon from the Taxpayers Alliance, which campaigns for lower taxes. Okay, to get the ball rolling, I'd like to get a single sentence answer from each of you to the following question. Is it right to deport Abu Qatada to a country where he may not get a fair trial? First to you, Martin.
No, it's not. It's a fundamental right of all of us to have a fair trial. Without that, there is no proper justice.
Okay, and Emma?
I think it's right that he has a fair trial, and I think that the British government should do all it can to seek assurances from Jordan that he will have a fair trial.
And Hannah?
I think it's right to try and deport Abu Qatada as long as it's done in full compliance with ECHR.
Maybe going backwards a little bit. When I introduced the case of Abu Qatada, he was described as a truly dangerous individual. Martin, do we know enough about him to make that claim?
Well, what we do know is that he hasn't been charged or convicted of anything in the UK, although he's served the equivalent of a 20-year prison sentence in time that he spent banged up inside Belmarsh and other institutions. We do know that he's been convicted of 2 terrorist-related offences in his absence in Jordan. But really, until such time as he faces a fair trial based on evidence obtained in a normal way, not through torture, the presumption of innocence must apply even for a man with the supposed history that he has.
Where do you think this should happen?
Ideally, I'd like to see this man tried in the UK. If there are offences that we think he has committed, that we have evidence of, he's here, put the charge to him, put him in court, let's have open evidence and try him here. There is a significant problem about charging and trying this man in Jordan, and that is that there's plenty of evidence that's been before the European courts and indeed our own courts that A, there's a risk of torture for himself, and B, that the evidence that he will face in Jordan comes from the poison tree of torture. If I were to pull your toenails out, bash your teeth in, put pins in your eyes, electrocute you, if I asked you, is black white, you'll say, yes, black is white. The quality and credibility and value of evidence obtained under torture is useless unless we are assured properly that in Jordan the evidence that he will face will be through normal investigative means. Then this man ought not go to Jordan.
Hannah, do you think we have those assurances?
From the Jordanian government at the moment, I'm not sure. I'd like to see what the courts say about that. Theresa May, in her statement on Tuesday, she listed a variety of assurances, particularly one that his co-defendants would be able to give evidence and that he would be able to challenge it, that he would have legal aid, and that particularly any evidence that they gave would not affect any pardon that they may have, which Theresa May said would mean that they would likely tell the truth. I'm still not sure about that. I would like to see that go through the courts.
And Emma, do you think we're just offloading a case to Jordan that we can't handle ourselves?
No, I think if there was any intention of holding this trial in the UK, it would have happened many years ago. This is a man who's been in the UK now, whether he was in or out of jail, living at taxpayers' expense in the UK, plus all of the costs of the legal aid, plus all of the costs of imprisoning him, and when he was out of jail, the costs of the police and the MI5 agents to protect him from any sort of potential vigilantes. So I don't think there's ever been any real question that this trial would happen in the UK. This is someone who, as far as the British government seems to be concerned, doesn't have any right to be here. But the problem is they just haven't been able to deport him because of the European Court of Human Rights. And it does seem unfair that British taxpayers have had to, in the meantime, whilst all this wrangling has been going on, had to continue to pay for him. Of course, we should do everything we can to ensure that he won't be tortured, that he will have a fair trial if he's deported back to Jordan. But we've been trying to do this for many, many years now, and it just seems that we're not getting anywhere.
Can you put a price on justice, though?
Look, this isn't a case of can you put a price on justice, this is a case of can we actually get anywhere with it. There doesn't seem to be any movement. The British government says one thing, the European Court of Human Rights says another. The British government can't get its own way. We can't enforce the laws that we want to enforce in our own country, which doesn't seem right and doesn't seem fair. It isn't a case of putting a price on justice. If you look at the legal aid costs that have been run up in this case, Abu Qatada will just keep appealing and appealing and appealing as long as he can. And the problem is that he ran out of courts to appeal to in the UK, so he's had to go to the European Court of Human Rights.
When I first came across this case, that's exactly what I thought should happen here. And then I looked into it more, and I actually don't think it's feasible. A lot of the things that he did in the 90s, though now looking back, we would say this is crazy that he can't be convicted, but a lot of the stuff actually falls under the Terrorism Act 2000, so his activities predate that. What he could have been perhaps convicted for was soliciting to murder. But in terms of the type of ideologue he is, the sort of spiritual ambassador of Al Qaeda in Britain, the kinds of cases we've seen of similar ideologues, notably Abdullah al-Faisal and Abu Hamza in 2003 and 2007, while they were convicted on multiple counts, each count was only 7 years, and they weren't allowed to run one following one another. So that is actually the equivalent of a 3.5-year prison sentence, and the rest is spent on licence. So had we tried to convict him for pretty much the only crime we could have done, the precedent we have is that he'd have been in prison for 3.5 years, out on licence for another 3.5 years, and then we wouldn't have been able to do anything other than surveillance. So I think the decision to deport him was the right one. We just have to make sure we do it in full compliance with the law.
Isn't the point there that he just wasn't guilty of very much? I mean, you call him an ideologue, so we're going to stick him in jail for his ideas?
I would say that Abu Qatada during the late 1990s was the most dangerous man in terms of al-Qaeda-inspired terrorism in this country. There were two, Abu Qatada and Abu Hamza. And Abu Hamza we've just successfully extradited to the US. He's the tabloid hook-hand favourite.
Sure, yeah.
He's a particularly dangerous man. I could list up to about 40 people that he inspired to go and commit acts of terrorism across the world. And Abu Hamza was only Abu Qatada's student. Abu Qatada was, I'd say, the most dangerous man in our country in the late 90s. And it's perhaps a mistake that we allowed him to act so freely. There are a number of people in prison across the world who are directly radicalised by him.
Martin, you obviously deal with these kind of cases and accusations quite a lot. Are you a little bit suspicious and cautious when it comes to those kind of allegations, though?
Let's take some of the emotion out of it. If any of your listeners are going to be banged up and face long terms inside in prison, they want that to be based on properly obtained evidence and actually based on evidence openly put before a court and tested before a court. They need legal aid to be able to do that, and we should be proud that in this country there is an equality before the law, because it's not only the rich that can afford to properly defend cases, but we have a legal aid system that allows all to defend cases, and we should support and be proud of that. Now, these cases are difficult cases, but we should remember that after 9/11, there was a knee-jerk reaction, maybe across the globe, but certainly here, to people who were being accused without having the evidence put up in front of them. And you might recall that quite a number of people were locked up inside in Belmarsh, the keys essentially thrown away, no charges brought against them. They weren't being deported because they would face torture in their home countries. They were not given the evidence that was supposedly there against him. And we ended up with those cases going in front of the House of Lords, a 9-person House of Lords in 2005, in a historic judgment, which said that type of conduct by us was worse than the terrors that we faced from the Nazis during the Second World War. That's a greater threat to our society, the traditions that we hold proud in this country. If there's evidence against someone, put up or shut up. Put it out there openly. Let it be tested. That's what courts and trials are about. If we were to believe every bit of secret evidence that's out there, then very many of us would be banged up. The whole legal system is out there to ensure that there is due process, that there is equality before the law, that there is a rule of law. And the whole terror regime that we've seen during the early part of this century has massively attacked that.
Emma, due process and not cutting corners?
Due process is, of course, important, but the key issue for taxpayers here is that this isn't about a case that's being decided in Britain. This is a case that potentially will be decided in Jordan if he's deported. But in the meantime, the decision about whether or not Abu Qatada is going to Jordan is being left up to the European Court of Human Rights. British taxpayers have very little say over the decisions that the European Court of Human Rights makes. There's very little accountability of that court to us here in Britain. Now, not only are we partly paying for that court, but British judges have to be bound by the decisions that are made in the European Court of Human Rights. Judges in Strasbourg can overrule decisions made by judges here in Britain. And that doesn't seem fair to British taxpayers who are paying for a British justice system and want that justice system. And instead, what they're ending up doing is paying for, and I agree that legal aid is important so that everybody has equal access to justice, but what they're paying for here is for legal aid for a case that is being decided by the European Court of Human Rights that's not being decided by a British court.
You say that British taxpayers don't have any control over the decisions that are being made in a court in Strasbourg. British taxpayers don't have any control over the decisions that are made in a court in the UK either.
Yes, but the courts in the UK, you're living in British society. You're part of the British justice system is part of our civil society. You agree to live here and be bound by its rules. That's kind of part of the deal. Whereas the European Court of Human Rights, to many people, is remote. It's something that it has overruled many, many judgments that have been made by British courts. And I don't think that British taxpayers really feel that necessarily they want a court in Strasbourg to decide what should be happening and overruling decisions that are made in British courts.
You're listening to The Voice of Russia in London. I'm James Reinl, and we're discussing the deportation case of Abu Qatada and the European Court of Human Rights in Strasbourg. I'm joined by Martin Howe, a human rights lawyer from the firm Howe and Co, Hannah Stuart, a researcher for the think tank the Henry Jackson Society, and Emma Boon, campaign director for the Taxpayers Alliance, which campaigns for lower taxes. I'm going to stick with you, Emma, for a second, because I'd like to turn to the activity surrounding Theresa May, the Home Secretary, over the past few days. And it seems, on the face of it, that there's been a degree of bungling in the Home Office, and they've got the dates wrong. The appeal for Abu Qatada, there was a 3-month window of opportunity for him to make that appeal. Apparently, the Home Office disagrees with the court as to whether or not that ended on April the 16th or the 17th. This is going to add to the bills that the taxpayer is going to have to pick up. Surely this makes you angry.
Potentially this will mean taxpayers have to keep funding Qatada while he stays here, whilst he appeals, whilst his family is here as well, because that's part of the cost to taxpayers of him being here. But the interesting thing about this is that no one seems to be able to agree on what the date was by which he should have lodged his appeal. And the Prime Minister told the BBC this morning that the Home Office did ask the court when the deadline was, and the court did tell them when the deadline was, and that deadline was the deadline on the Monday evening, which was the correct deadline that Theresa May thought was the correct deadline. The court now appears to be saying that's not the case. So it's unclear. Either the Prime Minister's right or the court is right. Who knows? But what is clear is that, yes, taxpayers will be on the hook now to continue to pay for Abu Qatada's to stay here and for his continued appeals whilst this is resolved.
I think David Cameron has now backtracked slightly, though. The latest I heard was not that they had definitely got an answer, but that the Home Office was working on the assumption that the deadline was the 16th. That's the latest. So I think that a senior source at the Home Office would only say that they were working on an assumption. So Cameron's now being accused of lying.
Martin, how can it be, you're a lawyer, how can it be so confusing as to whether or not you launch your appeal by the 16th or the 17th?
Well, farce and confusion is the definition of what's going on here. If we've got a Prime Minister saying one thing at 8 o'clock in the morning and then by midday having to retract it, doesn't surprise me, given that on Thursday last in front of the in the House of Commons, Theresa May on 14 separate occasions was pressed to say if she had actually bothered to check with the European Court on what was the correct limitation date. When did the time for appealing expire? And politicians are good at dodging questions, but 14 on the trot was quite a record. I think if they had checked it out, I thought they'd be coming out with it as quickly as they possibly could. It's a nice lawyer's point, isn't it? You know, when does time run out? Is it midnight on the 16th or is it midnight on the 17th? If you look at the rules, it does say the judgment, which is on the 17th of January, the time for appealing against that is within 3 months from the date that the judgment is perfected. And I'm sure there's going to be a lot of argument about the juxtaposition, those two words, and from being the crucial one. It's almost academic. I mean, putting that to one side, and what we are talking about is a very fundamental right. The appeal is being made against an allegation by Qatada's legal team that if he is returned to Jordan, he personally will be tortured. Now, the court was against him in the judgments on that point back in January. Where is something as important as the risk of torture to an individual is being considered? Where that point is being played out in front of a world audience, then I would be very surprised if the court turned around and said, 22 hours or 23 hours, if they are with Theresa May, and it makes all the difference here. We've had years and years of arguments and wrangling about it, and we're not going to even consider whether there is a proper appeal here. Now, what will happen next is that the application to go to the Grand Chamber, this case was heard not by the Grand Chamber, in the decision that was made on the 17th of January. The application now to go in front of the Grand Chamber will be heard within the next 3 months by a panel of 5 judges. If it's successful, it will go in front of a 17-panel judge Grand Chamber the next 12 to 18 months. That's the timescale we're looking at.
OK. Hannah, can you make any prediction about what's going to happen as the case proceeds?
Well, Martin's right. The Grand Chamber has to decide, and that's within 3 months. And then I think if any decision is made, it's then 8 to 12 months. Theresa May was clear, even when she gave her speech thinking that she'd successfully resumed deportation on Tuesday. She was right then to say that it wasn't ever going to be a case of days. Even if the deportation had been allowed, even if she'd been within the deadline, he would have still been able to appeal. But he would have appealed on a much narrower basis. He would have solely appealed Article 6. And that's why Theresa May was so happy on Tuesday that she'd played her hand the way she had, because any appeal process would have been, she said, much shorter. That's why she said on Tuesday she was happy that it wasn't going to a Grand Chamber decision, because that would open up all of the articles, particularly Article 3, which the UK had successfully won in January. And that was a really big moment for the UK, because we've been trying, in many cases and failing, to get deportation with assurances to a variety of governments. We tried with Libya, and ECHR said that wouldn't work. We intervened in a case with Italy in 2008, where Italy were trying to deport suspected terrorists to Tunisia, and we were a third party to that, and we were trying to argue that assurances were enough. And again, ECHR said assurances were not enough. So it really was quite significant in January that the processes that the Home Secretary had gone through with Jordan were considered enough by ECHR. So it is a big mistake for Theresa May that area has to be reopened. That's why it's going to take longer. I would predict maybe 12 months, 18 months.
And Emma, I guess that doesn't fill you with great optimism.
No, it doesn't. In the period that Abu Qatada's been in the UK, he's got a family here. And if you count up all of the benefits that his family have claimed as well, and you add in the legal aid, and you try and, you can estimate what the cost of keeping a man in prison has been over that period, and estimate the costs of the police and the security for the period when he was released from prison under the curfew order, where he had to stay in his home for 22 hours a day. He was still considered to be a very dangerous man, and obviously was considered to be potentially a victim of vigilantes. So if you add all this up, he was, just in benefits alone, we're talking like £50,000 a year for his entire family. So we're talking millions and millions of pounds already, and this is only going to add to that.
You're listening to The Voice of Russia in London. I'm James Reinl, and we're looking at the deportation case of Abu Qatada and the European Court of Human Rights in Strasbourg. I'm joined by Martin Howe, a human rights lawyer from the firm Howe and Co, Hannah Stuart, a researcher for the think tank the Henry Jackson Society, and Emma Boon from the Taxpayers Alliance. Turning to this case of the European Court of Human Rights based in Strasbourg, it's a European institution but not a European Union institution. This falls under the 47-nation Council of Europe. It's existed since the Second World War, and it rules on grievances of individuals who believe their national courts have failed to deliver justice. Now, there's been a bit of a bone of contention between a few of the member nations of the court, Britain included, and this all came to a head last week in Brighton with a meeting between the 19th and 20th of April, in which some of the problems of the court were sought to be addressed. Emma, I'm guessing you have a few issues with the court. Maybe you could explain the case for the problem of this institution.
The European Court of Human Rights has overruled several dozen judgments made by British judges in British courts since its inception. And the difficulty is that those cases have already been all the way through the British court system often, and that's already come at a significant cost to taxpayers and has already reached the final court of appeal in the UK, which is what we agreed is the final court of appeal as part of our justice system. Now, once that decision has been made, depending on what the case is, people have a right to appeal to the European Court of Human Rights, and yet British taxpayers in many cases feel that this distant court is overruling decisions made by British judges and imposing laws, imposing judgments on our system, on British people, effectively. If you take the example of a recent case which was looking at whether or not prisoners should have the right to vote, regardless of whether or not you think prisoners should have the right to vote in the UK, they don't at the moment. This was a case that was brought by a British inmate. He took it through the court system here. He appealed to the European Court of Human Rights, and the European Court of Human Rights said that he should have the right and prisoners should have the right to vote in the UK. And the difficulty is, whatever you think about whether or not prisoners should have the right to vote, I believe, and many taxpayers believe, that that is something that should be decided here by British courts, because you're talking about British citizens in British jails voting for a British government. So it seems inconceivable, and that's just one example of when the British courts have been overruled, that we can continue to go on in a situation whereby our court system is overruled by the European Court of Human Rights. And in many cases, those judgments could cost British taxpayers money. For example, whether or not prisoners should be allowed to vote could open the floodgates for millions of pounds in compensation claims, as prisoners who haven't voted in recent general elections bring compensation claims against the British government.
Martin, it's expensive, distant, and imposes judgments on us that should be decided on our own turf. Do you agree?
Not everything in life is judged in pounds, shillings and pence. Fundamental rights, such as a right to a fair trial, a right to life, a right not to be tortured. These are fundamental rights that affect human dignity. And I think we're losing our way a bit if we are trying to cost out on each and every
those rights. I believe that British courts would not ignore fundamental human rights. Why do we need a whole extra court in Strasbourg?
And we have, thankfully, we have a Human Rights Act here, which incorporated the European Convention on Human Rights into domestic law. And in the great majority of cases, our courts do apply the convention correctly. Now, and let's remember the history of
that means we don't need it.
But let's remember the history of it. This court arose out of the horrors of the Second World War. This court was the brainchild. It's the legacy of Winston Churchill and his team, something that we should be very proud of. The ability of individuals across the 47 states, 800 million people, the individual right to petition this court is at the core of what was dreamt up and brought out at the time in the early 1950s, and is still an important and core part of it. In order to have fundamental human rights that are applied universally, and particularly across the 800 million people of the Council of Europe, we need an overseeing guarantor court. And the European Court of Justice, which is a very serious court, acts in that way. It pulls together the jurisdiction and the jurisprudence from all 47 states and ensures that there is an equality of approach, be it in the war fields of Chechnya or for bankers here in London. And we need the court to ensure that uniformity and consistency of approach to fundamental rights across the 800 million people.
Hannah, is that right? Do we need a court in Strasbourg to tell us here in the UK whether or not we're living up to our human rights obligations?
I believe we do. I agree with Martin. I think it's problematic sometimes when people use words like this court in Strasbourg. It's very remote, it's distant, foreign judges. These sorts of words imply that it's somehow a completely different system is being applied. It's not. It's just the final arbiter on law which we've signed up to, as 47 European states have. It's our Human Rights Act. And I think the most important thing is that these human rights, the whole point of them is that they are universal and they are applied across, in this case, the European Convention, across Europe. But many of them are the same rights that we've signed up to in international conventions, which we see as inviolable and universal. So it's not a different legal system telling us what to do. It's a final court holding us to our universal responsibilities. And even if the way that some people are talking, some of the Conservative MPs saying we should pull out of Europe, we should put this murderous scumbag on a plane and send him home, even if we did pull out of ECHR and the Council of Europe, we still have these obligations under the Universal Human Rights Act. What kind of society do we want to be if we pull out of ECHR and the Universal Charter of Human Rights? I know it's difficult to say this. I know it costs a lot. I've seen figures of Abu Qatada personally costing us £500,000. But I think I would rather pay that in my taxes than pull out of ECHR and the Universal Charter of Human Rights.
Emma, maybe you can clarify what you actually advocate here for.
I think that the European Court of Human Rights has overruled too many decisions made by British judges. I find it incredible that anyone could suggest that those judges sitting in that court know any better than British judges sitting in British courts. There's been a lot of talk of fundamental human rights here, and I'm certainly not advocating that we should say that people don't have human rights. My concern here is that the European Court of Human Rights has taken that concept, which is a very noble and very correct thing to want to protect, which is people's human rights. But unfortunately, in too many cases, it's been twisted and has been used. The European Convention of Human Rights has been used to overrule judgments by British judges, has been used to defend things that I don't think people would consider have anything to do with things like stopping torture or protecting people's human rights. And I think that the definition of human rights has been stretched too far by too many people now.
I think it's important, as I said, with this intertwining of states, that countries that have perhaps not as noble human rights records as us ourselves, particularly Turkey, Romania, Russia, that these countries are pulled up to the same level. Turkey has been deporting suspected terrorists where they're at risk of torture. It's important that there is a final court that holds these countries up to the same level that we are hopefully doing ourselves in our courts.
Yeah, I mean, if we were to pull out, what message would that give? If we go to Syria and we accuse the Syrians of human rights abuses, and we say that we're going to oversee you and we're going to take you in front of courts and hold you to account, but we ourselves are not prepared to open our books up. We're not going to allow anyone to oversee us on these issues. That's the wrong message. We shouldn't just cherry-pick the cases that we like. You mentioned the prisoners case. There's a myth about the prisoners case. The European Court didn't say that all prisoners should have a right to vote, but it did say that there shouldn't be a blanket ban. All the court really was saying was, don't have the blanket ban, let's just have a look at the proportionality of it. And of the cases that go from this country to the European Court, only 2% or thereabouts are held to be admissible, because there is a filter at the beginning. And of the cases against the UK that have gone up in front of the court, about 60% have been successful. It is a proper arbiter, a guarantor of human rights across 800 million people.
That was Martin Howe, a human rights lawyer for the firm Howe and Co, warning that Britain pulling out of the European Court of Human Rights would send the wrong message globally. I was also joined by Hannah Stuart, a researcher for the think tank the Henry Jackson Society, and Emma Boon, the campaign director for the Taxpayers Alliance. You're listening to The Voice of Russia in London. I'm James Reinl. Stay tuned for the latest update of world news.